Welcome to my YouTube channel at Official Joel TV. On today's episode, we'll be speaking about the capacity of an illiterate to enter into a contract. Stay tuned and let me walk you through it. Though all men are created equal before God, but that's not the case when it comes to the law. There are special people in different categories whose special provisions has been made to protect them because the law considers them as feeble. These are infants, illiterates, and drunkards. Well, our focus for today will be the capacity of an illiterate to enter into a contract. In law, an illiterate is someone who is unable to read with understanding and to express his thought through writing in the language used in the document made or prepared. Well, however, since an illiterate is unable to read, write, and understand a document, such a person shall need or will need an assistance of a literate person. Hence, the need for an illiterate jurat. Then, who is an illiterate jurat? An illiterate jurat is someone who writes the document on behalf of an illiterate person. Section 3 of the Illiterate Protection Act makes provision for this and lists out all the requirements that must be fulfilled by the writer, that is the illiterate jurat. It provides thus: any person who shall write any letter or document at the request or on behalf or in the name of an illiterate person shall also write on such letter or document his own name as the writer thereof, and also write his own address. And in doing this shall be considered as a statement and the document shall be binding. The purpose of this is that the provision of the law ab initio is to protect an illiterate. So in writing his address and his name, the law traces or creates an identity for the writer. Furthermore, it is strict principle of the law that the court cannot presume illiteracy on a party. Rather, it must be established in evidence with the burden of proof being on the party who assert it. Meaning, the law cannot presume that you cannot read or write or you don't understand what is in the document. It is on you who claim that you are an illiterate to prove with evidence before the court. However, the concept of illiteracy also can only apply to a written document or contract. It doesn't apply to an oral contract. The reason is because illiteracy does not necessarily suggest infirmity. Because you cannot write or understand a language, or you can't write, you can't read, doesn't mean you cannot comprehend what is being said to you orally. And that is why the case is different when it is a written document and an oral document. In conclusion, capacity to a contract is one of the most essential elements of a valid contract, the absence of which is fatal in a contract. However, in order to ensure that illiterates are not defrauded during a contractual relationship, there are several other principles of laws to be taken into consideration prior to the formation of a contract with an illiterate. So, to this end, I believe that we now understand that an illiterate has capacity to a contract only when he or she has contacted an illiterate jurat. An illiterate jurat who helps in the formation of this contract, after which he or she has explained the exact terms or writes this exact document or contract in accordance with the terms of this illiterate, which means the illiterate jurat must explain the exact terms of this contract to the illiterate, and the illiterate must consent to whatever the illiterate jurat writes down. So, and also the illiterate jurat puts his identity in this contract by stating that this contract is written by him, or this contract is written by him, and also states his address in this document. This is Official Joel TV. I do educational videos like this. Please subscribe to my YouTube channel.